Hi, I'm Greg with the Ashcraft firm, and I'm an attorney here, and I do estate planning and wills and trusts and things like that. And one of the questions that I get a lot of times when I have clients in my office is, what if people don't accept the role of being in charge of some part of the estate? And that actually happens quite a bit. Usually in our process, when I'm sitting down with a client, I have I have 4 steps after somebody's signed up. And the first step is I get them a summary, and the second step is they look over the summary and they can discuss the particulars of their case with the people that they want to appoint. But if you are being asked whether you can serve, there's some things that you need to know before you say yes. The first thing is, what is a trustee or what is an executor? So a trustee is the boss of a trust, and they're going to be taking care of the finances of the trust. An executor is a lot like that, except an executor is the person who's in charge of a will. Now, if somebody's asking you to be guardian, that means they're asking you to tuck their kids in at night. And that's just for minor children. Here in the state of California, a conservator is somebody who's in charge of somebody who's not a minor, and that's dealt with through the court. Guardianship is also dealt with through the court, but a parent can nominate their guardian. And so those are the things to think about. Is if you're guardian, that doesn't necessarily mean that you'll be in charge of the finances. And if you're executor or trustee, it doesn't mean if there are minor children and the person and the parent passes away, it doesn't mean that you're going to be taking care of all of the roles. So be very clear about what it is that you're saying yes or no to before you say yes or no. But there are different ways to say yes or no. It's best if you're creating a trust, it's best if you talk to these people before you've appointed them, before you've officially appointed them in your documents. So some things to keep in mind is if it's before they've created the trust, it's obviously the easiest to take you out because they don't even have you in any documents. However, if you are put into a document, you can say no to the role of either trustee or guardian or executor. And there's usually a way spelled out in the estate planning documents. So if you're saying no to the trustee position, there's a spot in the trust how you can say no. If you're saying no to either the executor position or the guardianship position, then that's gonna be in the will. So there are ways to say no to any of those, either before somebody's put you in their documents, or after they've put you in their documents, or after they've passed away. You can still say no. So that's why I normally recommend to my clients to talk to the people that they've want to put in charge, so that they can say no now. So that way it never gets to a point where the court needs to actually deal with it. Because if you've listed some people out and none of them will say yes, then eventually somebody has to make the decision. And if your estate planning documents don't say something to the contrary, then it will go to the court for the court to decide. And that's a lot of reasons, avoiding the whole court process is a lot of the reason that you've created that estate plan. So, but if somebody is asking you to be trustee, you don't have to know all the legal and financial issues that'll come up. You can actually use funds from the trust to pay for help in those areas. I often assist people in doing either trust administration or probate. A probate is something you do for a will. A will has to be probated. Trust administration obviously is administering a trust. So you can get help with those really specific legal financial issues. Now, it does require you to follow the terms of the trust or follow the terms of the will, depending on whether it's a trustee or an executorship. And you are required to be organized. And so you're required to do things in an orderly fashion and things like that. If somebody is asking you to administer a plan, it's it's fair to ask them what's in the plan. It's fair to ask them to go over it with you or to look at it, because if the different plans are either more or less complex. So you do need to consider the complexity of the estate, the complexity of the issues. If they have a special needs child, being trustee is going to be a lot bigger job than if you're just gathering everything up and then distributing it, because you'll have to keep it in trust for that special needs beneficiary's lifetime. So that's something to keep in mind, how complex the estate is. Um, I People hesitate to say no. It's better to say no now so that these people can make different accommodations. But another thing to keep in mind, how close you are to the estate. If it's across the country, it's going to be more difficult to administer the estate for this person. So if you're nearby, that makes it a little bit easier to administer the estate. So those are a few things to consider when you're determining whether you want to take on the role of trustee or the role of executor. And also there's issues with guardianship. How well do you know the kids? Would you have to move the kids out of their home? Would you be able to take care of them in their home? Those are all things to consider if you've been asked to be the guardian. And you can also call us if you need help with things like that, appointing a guardian, determining whether you want to be a guardian or a trustee or an executor. We can help out with those things. Thanks so much. I'm Greg with the Ashcraft Firm.